Good morning. This is an interview with Ethel Sorokin by George Hastings for the Connecticut Bar Foundation's Women and the Connecticut Bar Oral History Project on today, January 8th, 2001. Now, Ethel, good morning.
Good morning. It's nice to see you.
And likewise. And let's start with the basics. When were you born?
Well, that's a very personal question, but I was born on September 17th, which, as you know, is Constitution Day, in 1928 at the Mount Sinai Hospital in Hartford, which was a little brownstone on Capitol Avenue.
Thank you. Well, I'm not supposed to talk about myself, but I was born in 1928.
Well, that's very nice.
Great year.
Yes.
Well, were your family living in Hartford at the time?
Yes, we lived on William Street on the side where the Clay Hill School is now, in a house that my grandfather had built. He had a magical 10 fingers, and not many people have inherited that quality in our family. And he built that house and lived there, and he died about 8 years before I was born. And my parents, who were in California, came back so that my mother could take care of her younger brother. So I was born in that house on William Street. And when I was about 3, we moved to Farmington Avenue, just west of West Hartford Center. And I lived the rest of my life until I married in that house. And then I moved to the house I'm in now. I've lived there for 50 years on Haynes Road near Bishop's Corner.
Right. Whereabouts in Farmington Avenue?
Just, you know where 4 Mile Road is? There's a marker on the street.
Yes.
On the corner. It's now an optician's house or a chiropodist's home and office, but it was our home.
Yes.
They have a parking lot where we had the apple tree under which Milton and I got married. So that was a while back.
Well, I remember that, I think, because, again, that was part of my turf. I lived on Westland.
Oh, of course. I walked by there every day to Sedgwick School. Did you go to Sedgwick School?
Yes.
That's funny.
And you did, too.
Yes. I was in the first class that went from kindergarten to 9th grade.
Well, I arrived in 4th grade.
Uh-huh.
Well, we're not supposed to talk about me, but anyway, what business was your dad in?
He had what was then called the Capital Paper Company, and later they bought out the Standard Paper Company, and that was a wholesale paper company. Actually, his father had been in that business when he was a young man, and when his father died, he and his brothers sold the business, set aside a portion for their mother, and they each had something they wanted to do. And my father hadn't been to college. He wanted to go to college. And he married my mother, and they started college together at Valparaiso University in Indiana. And then my mother got pregnant the first semester, and so she only went for 1 semester. Then she started the next fall again, got pregnant again, and had 2 children, 2 boys, and so she never finished, but my father did.
You graduated?
As a civil engineer. And then they went to California, and he was a civil engineer there. And when my mother's father died, they came back here. My mother had 5 brothers, 4 of whom were younger than she, and some were still in high school. And so she came home to maintain their home. And my father bought back the very business that he and his brothers had sold from the bank. It had been in receivership of some kind. And so they had that business with a different name. And that remained, it still is in the family.
And so you started Sedgwick School, which was then an elementary school and a junior high school.
Right.
Did you go to kindergarten? Did they have a kindergarten?
Yes, I went to it was a gorgeous kindergarten with a little pond for goldfish and its own kitchen. It was a very high quality kindergarten. And Miss Morcom was my teacher, and my children had Miss Morcom at Bugby when they went to kindergarten.
Oh, I remember her.
Yes.
Well, of all these brothers and people, were any of them lawyers?
No.
Now, Valparaiso has a law school now. Did it have one then?
No.
And So after Sedgwick, what happened to you?
I went to Hall, and I just walked the other way. Instead of walking on Farmington Avenue to Westland Street, I walked on Farmington Avenue to Main Street and went to this very building, which was Hall then. And then I graduated from Hall and went to Vassar College.
And did you have any inkling in those days, high school or college, about becoming a lawyer?
Not at all. I never thought about it. All my life, I had 4 things that influenced me in my life. My mother, who always said every woman must have a profession. And a good profession for a woman is being a school teacher, because she can have the same vacations as her children. And it doesn't mean you have to stop being a wife and a mother. And she always named a congresswoman who voted for peace in 1917 instead of going into the war. And she baked her own bread before she went to Congress. Rankin, yes, thank you. And when I got a little older, I used to say, I don't want to be a school teacher. I don't know why I didn't. I now think it's a marvelous career, perhaps the best career to be in, the most important. But then I just didn't want to be a school teacher. And then my father would chime in. He never talked about what a woman should be educated to do, but he would always say, if you're going to study something, study chemistry and physics. It's the basis of life. And so I would say, I don't want to be a chemist or a physicist. And then both my mother and father will say, all right, be a doctor like Aunt Rose. And I had an aunt here in Hartford who was one of the first women physicians, I'm sure. She was an allergist. And she went to medical school after she was married. And so she was a good example, a good mentor, because she was someone who was very active in a lot of different things mentally. Not that she participated in a lot of organizations, but there wasn't any subject she wasn't well informed on. And so she was a delightful person to be with. And she came to our house every Monday night for dinner. So that was very nice.
So that was a career woman, at least,
yes,
that you knew.
And she was married and very devoted to her husband.
So
that was a possibility. So I'd say, oh, maybe.
What did you major in at Vassar?
I majored in political science because it had the least requirements of any department in the entire college.
So you had more electives.
Yes.
And did you go right to law school, or?
I did, but an influence intervened. I met Milton Sorokin on my Christmas vacation junior year. And Milton Sorokin was the son of a grocer in East Hartford. They had a small mom-and-pop grocery store and 6 children, and the whole family worked in the grocery store. From the time you were 3, you had a job assigned to you, and you progressed up the line. The first job was counting out a peck of potatoes, and next you graduated to onions, and next you graduated to something else. It was like a Montessori education. And when you were 16, you were allowed to run the cash register, not before. And they lived behind the store and over the store, and they had 2 different stores at different times. And when I met Milton, his father was really retired already, and his mother both, and he was in law school. And I met him because his father was just selling his business, and an uncle of mine who worked with my father, was a partner in the Standard Paper Company, called on a lot of small businesses to sell paper goods, and he knew Mr. Sorokin, and Mr. Sorokin said, my son, Milton, is going to be on vacation from law school. And my uncle said, Philip Klein said, oh, my niece is going to be on vacation from Vassar. And Milton called me up, and my mother answered the phone, and she said, well, she's not here. She's visiting her cousin, Phyllis, who was the daughter of that uncle, on Newport and Sedgwick Road. And so Milton, she gave him the number, and Milton called me up, and we talked on the phone for an hour before we met. Milton's not here to defend his memory, but he claims I talked the whole time. However, that was wrong. He talked the whole time. So that was the start, and then we went out on a date during Christmas vacation. And my mother was having a Hanukkah party where the whole family, probably 25 relatives, were present. And Milton was picking me up, and I wasn't ready on time, and he had to meet all the relatives. And he liked people who were on time. And it was very important to him. He thought the most important thing of a lawyer was
you weren't going to attend the party.
Yes, I had already...
He just blundered into the party, so to speak.
Right, that's right.
Because you were still getting ready.
I had already been to the party, and I was now getting dressed to go out. And so he had to wait and talk to everybody. And although he complained that I wasn't ready on time, he enjoyed himself just the same. And so we went to the movies, the Loews Poli, and we parked on Wells Street. And of course, there was always a question for a woman then, should she open the door herself or wait for the man to open it? And my brothers always said to me, do something useful, powder your nose, and let the man open the door. So that's what I did, and Milton started walking up the street. He came back, opened the door, and said, what's the matter with you? Don't you know how to open a door? So I said I was busy powdering my nose. I didn't have time to open the door.
You didn't say, my brother told me to do it.
No, not until years later.
Yeah. Well, and so he told you something about what studying law was like.
Right, and in fact, we were engaged. That was Christmas of junior year, and before we went back to school in September, we were engaged. And Milton, of course, had made up his mind very early, and I had not. I don't know that we should go into all this background in such detail.
Right. But it's interesting. Now, where was he at law school?
The University of Connecticut School of Law. And so I picked a topic. I had to write a thesis for my department, and I picked a topic on a legal subject. It happened to be one that's rather current, the conflict between the First Amendment right to a free press and the other provision for a fair trial. And the competition between a fair trial and a free press was something of interest, and so I did my thesis on that topic so that I could go home every weekend to do the research in a law library. Vassar had, the United States cases, but I felt I needed to have access to a bigger legal library, and that permitted me to come home every single weekend, which I enjoyed. So that was it. And one October, we were sitting in the old library at the University of Connecticut School of Law on Woodland Street. And Milton was doing his work. I was doing research for my thesis. And Milton looked up and said, you know what, Ethel, why don't you go to law school? We'd have a good time together. And I said, well, I'm willing to try. And I was looking for a profession that I'd been told all my life I had to have. And there wasn't anything I saw in sight. And he said, and I said, well, I'll try it. If I like it, I'll do it. If I don't like it, I want to quit, and I don't want to ever hear about it again. Of course, Milton didn't like quitters. He never quit on anything. And so he hesitated for a minute. He also honored his word completely, whereas I might have agreed and then changed my mind. A woman can change her mind. And he said, okay, it's a deal. And so then I applied to law school. They accepted me, and I went.
Now, this was... You said 1 October.
October 1949, our last year, his senior year in law school, my senior year in college.
Ah, so you went right from...
Directly from college to law school. Mm-hmm. And I didn't even have to take the LSAT.
Wonderful.
So UConn didn't require it then, Yale did, but 84 and 91 weren't built yet. So there wasn't a convenient way to go to New Haven, and I never thought of applying there.
Well, how did you like law school?
Whoa, I liked it a lot. First of all, it was a nice activity, better than any of the jobs I might have gotten as a graduate of college, but nothing else. And I had worked I worked while I was in law school for the Public Expenditure Council on a research project. But it wasn't, really exciting work. I did a survey of welfare women who's had a legal divorce. Why weren't they getting supported by their husband under the divorce terms of the Superior Court? And they were quite out of the, 20,000 people or families or more on welfare at that time in Hartford, in the city of Hartford. There were maybe 1,000 who had gone through the divorce courts, divorce to legal marriage. So I went through all of those records and did this research project for them. And I was glad I wasn't working. I enjoyed law school, and that was a nice little project, but I wouldn't have been wanting to work at any office full-time then, I don't think.
Now, were you married at this time?
Oh, yeah, sure. We got married right 2 weeks after we graduated, and Milton had taken the bar, and we went on a 10-week honeymoon across country. And we had a very nice time, and while he was away, the Oscar Levine, who was the head of a law firm, Levine and Katz, which later merged with Ribicoff and Kotkin, spoke to his brother, who was a dentist in the same building, and said, in those days, not many people passed the bar. There weren't many lawyers. And so your picture was in the paper when you passed the bar. And when Milton's picture was in, he spoke to his brother, said, I'd like to see your brother. Tell him to come in and see me. And Milton's brother said, he's on his honeymoon, but I'll tell him to come as soon as he comes back. And so he did, and he got a job with them right away. And as a matter of fact, when I graduated law school, they hired me, and I never looked for a job. So I didn't have to struggle with the problems that a lot of women struggled with to move into the community.
And that was Levine and Katz at the time?
Yes,
And,
Levine and Katz, and we stayed there. Milton was there 6 years, I was there 3. And one of the outstanding things they did, which we didn't recognize the value of at the time, was they only paid us $25 a week. The top law firm was maybe paying $100 a week to an associate. But they allowed us to have our own practice and keep 100% of the money from our own practice. And we were very conscientious about doing their work first. And we developed a practice from the customers of Milton's grocery store, Milton's parents' grocery store. He had driven the truck with his brothers. All those, today, every family has a lawyer in their family. In those days, they didn't. And a lot of those people came to see us, and they referred other people. And then my same uncle, who called on smaller businesses, he would refer people. And then I had another uncle in the same business who called on the bigger businesses, and he would refer people. And so it didn't take long when we had quite an active practice. I didn't have the courage to leave Levine and Katz because we had free office space, free secretarial, free facilities. Plus, we did their work and got an income from it. By that time, Milton was earning, I don't know, $75 or $100 a week from them, and I might have still been earning $25 because I was working part-time. We'd had our first child, and I was pregnant with our second. And Milton wanted to become independent. And I was afraid. He was always the one that wanted to go forward. And even when we wanted to get engaged, he wanted to get engaged. I didn't want to get engaged. We didn't know each. We'd only been on probably 20 dates. How did I know I wanted to spend the rest of his life, my life, with him? In fact, I talked to my parents about it, and I was shocked. They were prepared to throw me away just like that. All those years they had protected me and not let me do a thing and so on, and let me do a thing. And then all of a sudden...
Well, we know from those Jane Austen movies that
yes,
getting your daughter married off is a prime object of life.
that is true. I might even agree with it today. To marry your daughter or son off to a nice person is very, very important. But anyway, they were satisfied, and I thought at least my father would be concerned about the money. And I said, how do you know he'll even earn a living? Don't worry, he'll earn a living. Well, I got engaged with the idea that I could break it if I didn't like it. So I didn't tell anyone. And
well, when you were both with Levine and Katz, you did pretty much a general practice?
Yes, when I first came, there were 2 appeals to the Supreme Court of Connecticut, and I worked extensively on both of those. One was the first case involving the test case of the constitutionality of redevelopment, the Constitution Plaza redevelopment project, and so I worked on that. And in fact, it was argued in my first year there in February. It was the 1993-94 academic year, sort of. And in February 1994, and I was pregnant then with our first child, and I went in a maternity dress. And of course, a woman needs a new dress to go to the, or a new suit to go to the Supreme Court, and I couldn't buy anything but a maternity dress. I don't know if Oscar Levine was so happy when he saw me show up in a maternity outfit, but he didn't say a word, never complained.
Did you argue the case?
No, he did. He argued the case.
But you
and
were
I was,
there.
Yes. And I always thought I was the first pregnant woman to appear in the Connecticut Supreme Court. But at my son's graduation from law school, a woman speaker, a judge, said that she had appeared pregnant in the Connecticut Supreme Court on a case in late 1993 or early 1994. I don't know what month it was and whether she was first or I was first, but I'll give her credit. So.
Well, 93?
I mean, 53.
53, yeah.
Thank you.
Yeah, yeah. Probably a number of pregnant women had appeared by 93.
Yeah, I would say so.
Yeah. Well, did you said that Mr. Katz, or
Oscar Levine.
Oscar Levine didn't bat an eye,
No.
but you sort of, well,
I felt it was sort of a surprise.
what was the senior lawyer's attitude toward you? Did they protect you? They keep certain cases away from you?
No, he
or-
was always very positive and nice, and even when I did something wrong, he would just accept. He treated me like he treated Milton. He was very nice. And then we had another case, an appeal in a complicated will contest, and I worked on that with a lawyer who was on. There were a lot of lawyers involved in the case, and he was on our side, so-called. And so I worked with him on the case, and Oscar Levine had assigned that to me. And then I did other things. I did one terrible thing. They had a florist client who had referred a lot of collections to them, and somehow they'd fallen into the back of the file cabinet, and nobody had done anything on them for a while. He said, why don't you see what you can do with this? So he didn't give me any specific directions, so I sent a letter to every one of the debtors and said, pay your debt to the florist. Well, shock reverberated. There must have been about 200 or 300 of them. And it was all old, and they didn't want to be bothered, and the florist didn't want to hear about it. It was antagonizing his clientele. And so we just forgot the whole thing. And he didn't scold me terribly. I think he felt maybe he should have given more specific directions. And he had sort of expected that I wouldn't act so quickly, maybe. So that was my biggest error at Levine and Katz.
Did anybody send in any money?
I don't remember now. I was so overwhelmed with what I'd done wrong that I don't remember if anyone did or not. Maybe some did.
Well, and did you go to court alone?
Yes, and the first time I went to court on short calendar, it was in the city court in Hartford, and I didn't know what to do. I mean, I was told what to do, but when I got there, I wasn't sure. And Waxy Waxman told me what to do. He was very nice, and it was no problem. But of course, it had nothing to do with anything I'd done in school. It was long before the University of Connecticut Law School had clinical programs and so on. So I didn't know what I was supposed to do exactly, but everybody, the whole bar was very nice and helpful. And I didn't encounter, quote, discrimination. I did encounter it every day when I made a phone call to a lawyer's office. And I'd say, I'd like to speak to Attorney Hastings. Who's calling, please? Attorney Sorokin. And they'd say, just a minute, please. Well, would you get the attorney on the line? And I'd say, I am the attorney. I must have done that 1,000 times a month or in many, many years. At first it sort of enraged me, and I'd say Attorney Ethel Sorokin, and sometimes I'd say Attorney Mrs. Ethel Sorokin, and nothing seemed to help to make people think that I was the lawyer.
Well, secretaries, yeah.
Right. But I don't recall any discrimination from lawyers themselves. If they felt it, they didn't say it in front of me, or there were times when I saw lawyers do things I didn't like, but it didn't interfere with me. The biggest handicaps I had was I'd set this goal once I had children that I had to be home a certain amount of time, and that, I think, delayed my career a little bit. I never participated in bar things, which I might have enjoyed and found useful, but it would have been an extra activity. I didn't permit any extracurricular activities until our youngest child was in 6th grade.
So in all you had how many children?
3.
3.
The third one was born a little bit later, and 2 of them are lawyers. And the third one is a doctor. She's the oldest. She's a doctor. And she, when we were interrupted at dinner by phone calls occasionally, when she was in high school, she'd say, I think I'll be a doctor. I bet I can control my schedule better than you people can. And she does. She works half-time. She doesn't ever work a minute after 1 o'clock. If someone wants to see her extra and she doesn't have time between 8 and 1, she'll say, I'll be glad to see you at 7. But she won't work a minute after 1 and has control of her schedule. And she teaches bioethics, which is sort of legal. So I guess we've had an influence a little bit.
And your sons?
My son is a federal public defender in Boston, And my daughter is a partner at Dilworth Paxson in real estate and corporate in Philadelphia.
Got the East Coast, Northeast Coast.
Yes, unfortunately, none of my 8 grandchildren are in Connecticut. So I have to do a little driving, but I do.
Well, what about other members of, well, I guess you've already answered the question, but as far as your recollection was, you were treated well and in a matter-of-fact way by
Yes.
by the lawyers in Greater Hartford.
I don't think I was someone who was very offended by or sensitive to any mistreatment unless somebody interfered with what I was planning to do, and I don't think anybody did. I remember a case where I came to court on, I wasn't a litigator because that didn't fit in with being home half-time or three-quarter time, being home at 3 o'clock when your children were coming home from school. So I didn't go to court often, but sometimes to argue a motion. And I was there arguing a motion on a summary judge. I wanted summary judgment in a case, a declaratory judgment case, where we had sent notice, certified mail. And the other lawyer came and said, our clients didn't get notice of the certified mail. And I said, we didn't get it back. We've got confirmation right here of delivery. And he said, oh, that's just a secretary. My client doesn't accept certified, as a matter of policy, doesn't accept certified notice. Well, I said, there isn't any other way to notify him when he's in New York State. And we have an obligation to give notice, and so any business that doesn't accept certified notice seems to me is putting its head in the sand. Well, the judge ruled in my favor. The other lawyer was maybe not pleasant to me, but he wasn't discourteous or anything. He might have liked it better if it was a man on the other side, but I did what I did, he did what he did, and I didn't, pay any attention.
And at the time that you started practicing, were there, well, in your class at UConn, were there other
The 4
women?
women started with 65 men, and 35 graduated with 2 women. So I'd say it was about par for the course. The one thing...
You were one of the 2.
Yes. And the one thing that I think I always felt was sort of discriminatory, but when I look back on it, I think it was wrong of me to feel that way, was in the second semester of our freshman year, there were still 4 women, and we elected class officers, or maybe it was late in the first semester, I don't remember exactly. And the class elected the 4 women to the 4 positions of president, vice president, secretary, and treasurer. Well, I felt there was something discriminatory about that, and so I didn't do anything about it. Instead, I think now, and many years afterwards, I thought I should have taken a very active role and done something with that opportunity, viewed it as an opportunity, and a rejection by the male students that they didn't care about what happened to the law school, that they didn't want to participate. But I didn't. I resented it. So that was silly. Looking back, resentment is not a useful feeling. It doesn't produce any results. So I would say that in most things, it doesn't pay to be resentful. Either do something or don't do it.
Did any of, did you feel ever that clients were disappointed that the case was assigned to you and not to a male lawyer?
I don't think so. There was one conversation I had with a good friend who was one of our first corporate clients, and he had gone to college with Milton. He was in the same fraternity as Milton at the University of Connecticut. And in fact, I think Milton was president of the fraternity, and he followed him as president the following year. And he came to the office to discuss a retainer, an annual retainer with Milton. And Milton was held up in court and wasn't back when he came. And so he was sitting and talking with me in my office. We were just socializing. And he said suddenly, why don't I talk to you about the retainer? And I said, because you're probably willing to pay more money to Milton than you would to me. And he said, you may be right. And shortly after that, Milton came in and they discussed it. And of course, one reason he was willing to pay more money to Milton may be that Milton was a man. But the principal reason is, of course, that Milton dealt with the money in all respects of how to get it.
Yeah.
And I never dealt with the money about how to get it. Even when we started the Center for First Amendment Rights many years later when we were of council, before we were of council, but shortly after, when I said, you know, I'm sick and tired of trying to find money for every project. We ought to have an endowment. He said, great idea. He went to the phone and he immediately collected some money. That wasn't my domain. So the client waited for Milton, and Milton came in and they discussed the retainer, and he did pay more than I probably would have asked.
Well, later in your legal career, I may have the wrong impression, but I got the impression that you did get involved in law firm management.
Well, I expressed my opinion at law firm meetings, and I did certain things in the management of the law firm. But until we had an executive committee, you know, got a little bigger and had an executive committee, the principal manager was Milton. He was the one who might walk through the office, pick out sheets of paper that had typing, a little typing on one side, and say, why don't you use the back for scrap? And he might check on associates to see. We didn't have a formal associate program, but he might check to see what each associate was doing on a case he might have assigned to them, and to be sure we were having a high quality response even for a little case. That was very important. And I hired people. The first time I hired someone I didn't like, I made Milton fire her. It was a secretary. After that, I fired people. They didn't even know they were fired. One woman called me up and said, did you fire me? And I said, no, we just reassigned our tasks. But but there are still people with us for 20 years or so or more that have that I hired in the past. But once we had an executive committee, we had a much more organized and spread out firm. And so I was never really a prime mover in the management. I was much more active in practice of law. I had a rather active family practice. And then at one time, a client, a corporate client who had bought 2 newspapers, weeklies, and turned them into a daily, the Journal-Inquirer in the Manchester area east of the river, called. There was a woman publisher, Elizabeth Ellis, and she called and said, I want to sue to get Dear Abby. And I said, Betty, I have no idea how much it's going to sue to get Dear Abby, how much it's going to cost, but I'm sure that it would be better to spend the money on your 10 or 12,000 subscribers than to sue a major corporation. And she said, you don't understand. You can't run a daily newspaper without features like Dear Abby. And in any event, we did. It was an antitrust case. We weren't antitrust lawyers, but Milton and I took our youngest son out of school. If we had said, Leo, do you want to come to the office to make photocopies on Saturday with us, and maybe we'll go out to lunch afterwards, we would have gotten a rather cold shoulder from our 7th grader or 6th grader. And but we said, do you want to go to New York with us? You're going to have to miss a day of school and make photocopies for us at the Federal District Court on a case involving Dear Abby. And then we'll go out to lunch, and then we'll do something else, and so on. And he said, oh, I think I'll do that. And he was very willing. So we set him up with $50 worth of dimes. It was when photocopies only cost a dime or a nickel. In the hallway. And the Federal District Court had a wall, maybe as big as that wall, of this case, which had been pending for 10 years, the U.S. Justice Department against 3 major syndicators of features and the Boston Globe. And so in 10 years' time, there had been a great deal of discovery of leading experts in the newspaper field. There had been a great many briefs written by outstanding law firms, the best in the nation, on the subjects involved in the issues, summary judgment and other issues. And so we went through that and came home and read it all. We got a liberal education. We brought a state antitrust action, one of the first state antitrust actions, against the syndicator of Dear Abby. And the lawyers from New York were a little arrogant. They didn't think we knew what we were doing. They may have been right, basically, but we knew what we were doing in that one little area. And so we told them to come. We had it scheduled before a judge named Leo Parsky, who we thought might be sympathetic to something newish. And the day before it was scheduled, which was about 2 months later for a temporary injunction, the New York lawyers called up and said, we're going to let you have it. And the reason was they'd worked out a settlement of the whole 10-year-old case with the Justice Department, and they didn't want our little case where our client might have been paying $2 or $5 a week to get it, to have it upset that. And so we settled and got Dear Abby. We were very successful. We felt all we had to do was issue the complaint. And then it turned out there was a new law, the Dempsey Law federally, that permitted the public to comment on settlements in consent decrees of the Justice Department. That was the first time you could comment. So we commented in opposition to the settlement because the standard used was the Quincy Patriot, a daily newspaper in Quincy, which had 12,000 subscribers. And if you had 12,000 subscribers or less, you would be able to get any feature from anybody. If you had more than 12,000 subscribers, you would be bound by the same geographic restrictions that had barred our client out in Rockville from having Dear Abby by Hartford newspapers. So that was about a 17-mile restriction, at least. And of course,
because some other Hartford paper had it?
Yes. And so, so we objected to that settlement standard, and we claim that there's something that...
Well, this was after he'd said...
After we got our Dear Abby, after we got it, we wanted to have a standard that would apply to other cases for us, and we didn't like that standard because our client had...
Other features.
Yes, our client had 12,500 subscribers, so it was not going to be protected under the consent decree. And so we opposed that settlement and filed, and we made the mistake, you might say, of attaching our complaint in the Dear Abby case as an exhibit to our brief that we filed, and we didn't recognize or know that it was going to be printed in the Federal Register, which it was. So all the people that were calling us from small newspapers around the country who wanted our advice on how to get features immediately stopped because we laid it all out in our Federal Registry filing, and they did just what we did. They got it for free. And so but there were many other newspaper cases like that, the Davids against the Goliaths, that we handled, and it was a very interesting, and it was a joint project. Milton was a corporate lawyer, I was more of a family and estate lawyer, but this was one area we worked together and we enjoyed it a lot. It was one of the legal adventures that Milton had predicted. Well, so.
Yeah, lawsuits involving newspapers are interesting.
They are.
Somehow.
Yes.
I've had a few.
And newspapers are interesting.
Yes. Well, what are you doing now?
Well, now I am president of the Center for First Amendment Rights, which really is an outgrowth of that part of our practice. It was a small part of our practice if you look at what we did every day for 40 years, but it was a very important part because we enjoyed it so much. And so now I'm president of the Center for First Amendment Rights, which is a public educational foundation, and we run educational programs. We've on occasion participated in a case, amicus curiae, when let's say the Civil Liberties Union is blocked by conflict or something. But our principal goal is educational. And we run a high school conference. In fact, we just had this in October, and this is the invitation that went to high schools. And we had our about 200 students who, from all over the state who came with teachers. And we had a very interesting program. Jane Kirtley, who used to be executive director of the Reporters Committee for Freedom of the Press, and a fellow named Robert Gelman, who's a privacy consultant in Washington. It was very good. And then we had breakout sessions where students could discuss things and so on. And then our next program is this January 26th. We run a high school contest for high school students. We give prizes of 1,000, 500, 250, 150. And this year we decided we'd have a writer's discussion before students start to write in the contest. And it might improve some of the quality of the entries and so on, and it would be good for the students and make it more interesting. And so on January 26th, and this is the invitation for that, we have Nat Hentoff. I don't know if you're familiar with him, but he's a syndicated columnist, and he does a great deal of writing on the First Amendment. Yeah. He's even written books for high schoolers on the First Amendment. And so he's coming to talk, and the law school is very nice to us. They have They let us use the facilities there without charge. And so we're going to have it in Blumberg Hall at the law school. And I imagine it's not going to be a big group because we have people, we've never had 100 people enter the contest. It's less than that, and so I think that's all we'll have. All this may produce more entrants, I don't know. We're not necessarily looking for more entrants, we're only looking for the educational effect.
Is this statewide or?
Statewide, but we do occasionally have, to our high school conference, people come from Rhode Island, and occasionally we'll have people from Massachusetts. We also have a speakers bureau, and we also provide programs for teachers at their conventions and other places. And so when we do, we get some out-of-state people who get onto our mailing list and hear about things.
Well, you also put on programs for practicing lawyers.
Yes, well, we have.
Not limited to.
Oh, no, we have,
yeah.
these are just our last and our next.
Yeah.
We have the annual symposium this year. It's going to be on April 30th. That's for professional people and citizens of all kinds. And it's going to be on the topic of entertainment, violence, the nation's health, and the First Amendment. And last year we had a very successful one on public art, public money, and the First Amendment. It went on long after it was supposed to because of the interest of the audience.
Well, I went to one before that. I think it was on campaign spending.
Yes, that was one of our best.
Campaign
In fact,
finance.
the man who spoke about absolute free speech at that, Bradley Smith from the Capital City Law School in Indiana, I didn't know anything about him, but I had called Joshua Rosencrantz because he was executive director of the Brennan Center at NYU. And he said, I don't know him, I've never heard him talk, but I think the best person you could get on the opposite side would be Bradley Smith. And so I called him and he came, and they were both top notch. And we had a third man from a nonprofit in Washington. And then a couple of years later, not too long ago, Clinton appointed Bradley Smith to the Election Commission, Federal Election Commission, and Joshua Rosencrantz opposed the appointment very strongly and asked for tapes of our conference in order to use that material to oppose him. So that was an interesting outcome. It was a very interesting session.
Yes, it was.
Yes.
Well, I'm changing the subject a little. Now, when you and Milton formed the firm, you called it Sorokin and Sorokin
Yes.
to start with.
Yes.
And it was it was Milton Sorokin and Ethel Sorokin.
Milton and I never said whose name was first.
Yes.
But it was the two of us were the only people in the firm.
And did you and Milton bounce ideas off each other?
Oh, all the time, every day, all day long. Yeah. Oh, sure, we would. And we each had things we excelled at. I might make a suggestion, and Milton might act on it. Milton might make a suggestion, and I might do it. It depends on what it was.
Did you ever get in a real intellectual disagreement?
Well, we are basically very different people. He's very action-oriented. I'm very investigative-oriented, but not action-oriented at all. So we had a disagreement every day, even over the Center for First Amendment Rights. He said at breakfast one day, why don't we form a center for First Amendment rights in order to provide increased education on the First Amendment? I said, gee, that's a great idea. We were still practicing law. I said, what's it going to do? He said, just educational. I said, fine. He said, why don't you form the corporation and get the IRS qualification, the 501c3 exemption? And I said, okay. Of course, in the nature of the law firm, Milton assigned work to everybody there. And so I said, okay. But of course, I didn't do it that day. It was just for us. So I didn't do it that day or the next day or the next week. Well, you know, I began to have a dissatisfied partner who wanted action. So when he got dissatisfied, then I finally did something. And I formed the corporation, which only takes 5 minutes. I could have done it the first day. And then I filed the application with the IRS. And that didn't take too long either once you do it. Procrastination is a very bad characteristic sometimes, and found among lawyers occasionally. And So then we formed it in, I think, September 1993. It turned out we took of counsel status. Milton hadn't been well for some years. He had diabetes for 33 years, not that that ever impeded him. But as a side effect, he developed cardiac disease, and then he had a bypass operation, which was very successful, and 10 years later he had another, which was successful also, but left him with a lot of deficits. And he still practiced law, he was still very active, but he didn't have the same energy level. And so we decided to take of counsel status at the end of 1993. And so we had more time to devote to the center. And since Milton's died, I've made that a sort of activity. And the law firm gives me an office, and the law school gives me a place to have things. And so that's what's happened.
Do you, well, you're pretty happy with that you didn't become a school teacher?
Yes, although I sometimes think now that it would have been being a lawyer is very useful. There are a lot of things we did that were useful and very interesting, a very interesting life, I think, filled with ideas of different kinds. I didn't tell you about our first cases and what we did, but it is a very satisfying life. But I think being a school teacher is in a way more important because we now see that educational needs of our nation are much greater than our legal needs, really, at the moment. And we seem to have ample lawyers, but not ample school teachers.
Should you have told me about your first cases?
Well, they were very interesting to us. The first case...
This is when you formed your own?
Before we formed I was still in law school. And Milton was with Levine and Katz, but we had our own practice.
Yes.
We were allowed to have our own practice. My first case was a will, two wills for a woman who was in my class at Vassar and her husband. They were recently killed in the Egyptian air crash, but I was always grateful that she had the confidence to come to me and that her husband let her. And but one of our very first cases was a fifth mortgage foreclosure. My father's business, his partners and he, had a fifth mortgage on a boarding house on the corner of Spring Street and Asylum Hill. And they had sold, along with paper goods, they sold equipment and other things. And they had sold some little tiny stoves and refrigerators for, I guess, one-room apartments or two-room apartments, I don't know. And the second mortgagee was foreclosing. And we had, the second mortgage was about $30,000. We had a $500 fifth mortgage. So my father handed the papers to Milton and said, Milton, I don't know if there's anything you can do about this, but you might find there is, I don't know. And so, anyway, we need a lawyer to go to court at the foreclosure. And so Milton took the papers, and then we looked at it, we started talking about it. We looked up the usury statute, which said 12% or for a mortgage is a reasonable amount. Well, we thought a reasonable amount meant something between, let's say, 5 and 20%, or 5 and 18% for a mortgage would be reasonable. Well, this mortgage, like many second, third, and second mortgages in the nation, it happened, ours didn't have that. Ours was connected with a sale, so it had nothing extra attached to it. But this mortgage had an interest rate of about 20%, and then it had bonuses, and then it had legal fees and appraisal fees and a whole pile of other fees. It came, when you figured the whole cost out, it came to over 30%. We thought that was outrageous. We weren't very experienced in business. We didn't know about second mortgages. So we decided that we would claim the second mortgage was void for an unreasonable mortgage. And we both knew about a case from our leading professor, Professor Flavius Starr at the University of Connecticut School of Law, and he often talked about the Atlas case and the issues involved, which involved mortgage.
He lived on Westland Avenue.
Yes, he did.
Yeah.
I know that. In the second house in.
Yes.
And
I knew him.
yes.
When I was a little boy.
Yes.
Yeah.
And so we wrote a brief. I was still in law school. Milton was just starting out. And we wrote a brief, I don't know, 20 or 30 pages. And we come to court, and I went to and sat with the lawyers, even though I wasn't a lawyer yet. And there was no formal permission for a law student to do that then, but I did it. And the judge was Abraham Borden, who was a very nice guy. And he asked the lawyers to identify themselves and their interests. And so, you know, the owner and the first mortgage, all the second mortgage, third, fourth, he comes to the fifth mortgage and he says, and Milton stands up and says, I represent the fifth mortgagee, so-and-so, and we claim the second mortgage is void. And he said, you, I'll see in chambers. And we go into chambers. He doesn't even look at our brief. He drops it on his desk. He says, I just want you to know I have no intention of invalidating all the mortgages in Connecticut, second mortgages in Connecticut, because you claim that the second mortgage is invalid for interest over interest rates. And then we went back to court, and he said, I overrule the objections of the fifth mortgagee. And we learned our first lesson that you have to think of the practical business effects. But I don't think it discouraged us. There was a practical business effect, let's say, to the Dear Abby case, but it seemed unfair and wrong. And of course, one reason it was so wrong is everything began to be controlled by monopolies in the newspaper field. Today, most of the newspapers in Connecticut are controlled by national chains. There are only 2 or 3 that are independent. And I'm glad to say that our client still is. And so the same was true then. But anyway, that was interesting. Then the next case of interest was one that gave Milton the courage to decide. He gave our mutual notice to Levine and Katz that we were leaving before he consulted me, before he came home from the office, because I was afraid to leave. And we had a new death case. That was what gave him the courage. It was a man who was a friend of someone who had done some work for us and had become a client. And this couple and their 2 sons and their small daughter had been driving over Avon Mountain coming back from somewhere, and they were hit by a truck on their side of the road. And the little girl it was long before seatbelts and all kinds of rules about children, and the little girl was sitting on her mother's lap in the front seat. She was thrown under the dashboard. And the boys in the back weren't really, they had minor injuries. The father was driving, he had negligible injuries, and the mother had some injuries, but negligible. And we sued, created an estate for the daughter, sued for the estate, but we also sued for the emotional trauma to the mother, the father, and the brothers. And the insurance company objected, and that case, we didn't take an appeal, but we got what we thought was a good settlement. We lost the motion, but it was reviewed in the Michigan Law Review. There was a case note on it, and we thought we were hot stuff to have a case when we were just starting our own practice. Within a year after we started to have it reviewed in the Michigan Law Review as something of note. So we felt like we had brought something that was interesting. And we always tried to do something interesting ever after. So,
Did you notice, well, were there many women lawyers in Hartford?
No, there weren't very many. In fact, Ethel Donahue, who was a lawyer herself, she didn't practice, but she was a graduate of Vassar in the Pennsylvania School of Law, and she had a party every year for the women lawyers at the farmhouse that had belonged to her grandfather in Manchester. The property was taken partially by the highway 84, and it was divided, and she sold off the half on the other side of the property, originally to Pioneer Parachute. Now I imagine it's part of the mall out there. And she had this old farmhouse that she had redone a little bit, and she hired a caterer, and she served an elegant dinner to all the lady lawyers. And there must have been about 17 women there the first time I went, which must have been in about 1954 or 1955. And there were only a couple that were in practice. A woman named Sadie Glantz and another woman, her name escapes me at the moment.
Dorothy Kelmanson?
Oh, Dorothy Kelmanson maybe she was there. She had just started practicing. And no, another woman a little older than we were. And we were the 2 young women. And the rest of the women there worked for agencies or institutions, either insurance companies or the Immigration Department or the Justice Department in some other way, or some other organization as a lawyer, but not in practice. there was just one other who was in practice at that time.
Sadie?
Sadie and one other.
Yeah. Well, we're going to take a break now. Well, after our break, I've been looking at, we were talking about women lawyers, I guess, and your practice. What of interest to this subject might be whether you felt that you were particularly likely to get women clients.
Well, I did have women clients for divorces, many more women than men. And I was very sympathetic to the women's point of view. I was sympathetic to the man's point of view too, but I was sort of an early believer that it should be 50-50. And so I, perhaps for that reason, had many women clients. And I felt that very often they weren't as sympathetically represented by some of the other members of the bar because they didn't think about the women's side of the issues. So I think it was useful to be a woman in representing women in divorces and really complex family matters. And I wasn't of the school that liked to try. Of course, I wasn't a litigator. That may have been a reason, but I don't think it was. I think that I just didn't like to, I didn't choose to try cases, and if I did have a family case that needed trial, I would refer to someone else in the firm. But most of them, I believe they should be settled. I still believe that. I think it's better for the individuals and the family and the children. And it was a very interesting part of my practice, but it was a great many women. There might be a little conflict there as our practice grew because the women's side is not as lucrative as the men's side, usually, unless you have very rich women. And the law firm, as it grew, began to be more interested in making money than Milton and I originally were. We made plenty of money, and we never thought about it. But we didn't take a case only because of the money we might make. I mean, we like to make money like anybody else and pay our overhead and so on. But it wasn't an issue. But it became, in recent times, it's become more of an issue in every law firm. And so that handicapped some of the women I represented because I would take a woman because she had an appealing story or I liked her. I didn't like to represent people I didn't like. And I didn't like to represent people who I felt wanted to go to litigation because I wasn't going to do that. And so I would refer them to somebody else from the beginning, usually in the office. But it was, I think, a place where the women's role made an important contribution. And I think women have shaped family law a great deal.
You do?
Yes, women lawyers.
Do you have any thoughts about other ways in which the fact that there are more women lawyers, far more than there were, has affected the profession or the practice? Or?
Well, I think of women as sort of, as if you want to talk about a generalization, which is often meaningless, think of women as being perhaps more sympathetic, perhaps more on the cooperative instead of the competitive basis. But I don't know that that's true. As I look around at younger women today, there are many of them that are just as competitive as men, just who want to litigate a family case just as much as a man does. And I don't see that kind of difference so much anymore. But I thought of it originally as being that way. It was probably just a prejudice, maybe. I don't know. I think individuals make the difference. Whatever their personality and their outlook is makes the big difference in each matter. And each individual counts in the way that person makes a contribution or doesn't. But I don't think of it as a prejudice thing. When the first feminist book by the woman from Smith, in any event, came out, I wasn't very sympathetic to her book at first because she was busy saying how she was abused washing kitchen floors and doing this or that. I don't know if she'd gone to Smith. I went to Vassar. It seems to me it was the same thing. My idea of Vassar was every woman should do what she likes. I didn't choose to do that. In fact, I took the job when I was in law school at the Public Expenditure Council so that I could spend the money I earned, which was like $1 an hour. And I worked maybe 10 hours, and I paid a cleaning woman $2 an hour. And so that was my choice. I don't know why the other woman didn't make a similar choice, but she was resenting what she was doing. I didn't resent anything I did. If I did resented it, I didn't do it. And maybe that's why I didn't run into much discrimination. Maybe I evaded those situations where I might have run into it.
Did you have any other part-time work when you were in law school besides the...
Public Expenditure Council? No, because then I became editor of the Law Review, the then Law Review, which was a section, a student section of the Connecticut Bar Journal. And then after I was in practice, I became a member of the Connecticut Bar Journal Board of Editors, and I did that for a couple of years. And then...
So you were editor-in-chief of
yes.
the Connecticut Law Journal, the Yukon Law Journal,
yes.
as it was then constituted.
Yes, yeah. I was.
Did you enjoy that?
I did. I enjoyed it a lot. Of course, I'd been editor-in-chief of the Vassar Miscellany News, which I consider my premier employment and educational experience. There were 12 editors, and I was the editor-in-chief. And all 11 of the others were smarter than I. They were very smart people. And they were all willing to work. And there was never any arguments about, I don't want to do this or I don't want to do that. They're really exceptional. It was a fantastic opportunity.
And how often did that come up?
Every week.
Every week.
We worked on it every Sunday and Monday night. And when I took over, I was surprised to discover this institution of the campus was insolvent. There was a competing newspaper, a more conservative newspaper, and this one had been in business for a long time, and it was insolvent. And I tried to figure out why it was insolvent. I went to see our printer, who we owed a lot of money, and he said, "You people have pictures in every issue on every page." So I decided we wouldn't have no more than 2 pictures or cartoons. And then I went to the controller of the college, who was a very conservative fellow, and our newspaper was often talked about as being very radical. In fact, Cynthia Taft, a niece of Robert Taft, was an editor the year before me. She was one of the editors, and her role on this radical rag, so to speak, was written up in the New Yorker in relation to her uncle in Congress. And so it got a lot of attention that way. But the conservative controller said to me, "Well, give me a list of the people that owe you money." So I did, and he said, "Well, this restaurant I can use when we have to entertain someone in a restaurant. I'll have people in the college use that, and I will pay the bill to you through them." And then there was a taxi company that owed us. He did that with several creditors, and quickly our accounts receivable were eliminated. And then we reduced our expenses. The printer told me how we could reduce our expenses, which was the principal way to economize. And then the third thing was that we tried to get more advertising. And I made everybody on the editorial board, including myself, go to people who might advertise. And we got some more ads. I remember going to an Italian grocery in Poughkeepsie, and the man said, "Now, who's going to come here to shop?" And I agreed with him. I couldn't, how's that going to feed my children? And I had to agree with him. But we did get more ads. And then, when I went home for the summer, I got a letter from Chesterfield, their ad agency. They were going to cancel their ad on the back page, a whole page ad, every week on the back page. Not quite whole page. There was a little piece of text next to it. And so I was very upset, and I talked to my father about it. He said, "You write them back that you're going to raise your rates." I said, "I can't do that. Daddy, they will discharge me. They won't do it." He said, "They will never give you up. Just write back that you're raising your rates and you're outraged at their unilateral action of trying to." So I did. And I suppose it was my first legal style letter. And they didn't pay the increased rate, but they didn't reduce it either or eliminate it. So we were saved. And it was soon solvent again, and it was a lot of fun, and the people were very interesting. And so it was one of my most enjoyable experiences. So when I came to the Yukon Law Review, I thought that would be the same, and it wasn't quite, as free as the newspaper was, because we were doing all kinds of outrageous things and things that we were interested in and committed to and so on, whereas at the law review, you're doing what the cases produce. But in any event, it was enjoyable, and the people were interesting, and I enjoyed that too. And I wrote, I was involved in writing 2 things when I was in law school, and I think I wrote something after law school sometime too, on,
For the Bar Journal.
yes, for the Connecticut Bar Journal.
Did you have fun taking the bar exam, or?
I didn't mind taking the bar exam at all. I think we were very well prepared. And of course, I had this commitment that was less than Milton's, let's say, or less than a man's. I didn't feel I had to support anyone. And I had, at Vassar, everyone said a woman should do what she wants. So I went and took the bar exam, and I thought I should enjoy it. And so I did it, and if I did well, fine. If I didn't, I'd think about it. And
So
I had a freer attitude,
Yeah.
maybe.
You weren't under the gun, so to speak.
Well, I felt a little
You
bit.
wanted to-
I wouldn't like to fail at
Yeah, of
anything.
course. Yeah.
But
Did
it
you
was no
take a cram course, or?
I didn't. I don't know how popular they were then, but I didn't. I had my notes, and I had the best thing that happened to me in law school was I got the highest grade on a test that didn't count, which isn't too helpful. But I liked the professor, Starr, and it was in the first semester of our first year. He would give us a sample test on a contracts issue. He gave the same one every year to give people experience in taking a legal test. And then he gave us an answer as he would have approached it, which had all the alternatives, what he wouldn't say and what he would say and why he would say it and so on. Very thorough analysis of the problem. So one of the things I did before every exam was read over his analysis of that problem. Not that I would have, no matter what the course was. And he...
It was a methodology.
Yes, and so I did that before the law exam, and I reviewed all my notebooks, and I reviewed maybe a horn book or 2 for courses I didn't take, but I managed to go to the beach many days too. So...
You didn't feel, well, did you feel that as one of few women, were there few women taking it, or?
I don't remember many
Yeah,
women
yeah,
taking it,
yeah.
but I didn't feel that I had to worry about it as a woman. And even in law school, you know, law school for me was easier than college. Because in college, by the time you're a senior, you had to write a paper for every course, even a short one, every course, every week. And you had to produce all this material. When I went to law school, you didn't have to produce. You only had to take an exam. That's easy. And so I felt that law school was relatively easy compared to college. I managed to play bridge a little bit in the downstairs cafeteria of the law school, and I enjoyed the relax, and that's why I took the job, was that I didn't think it required full time. So I wasn't afraid about the bar exam, and I don't think I thought about whether men or women, I never thought about that men might pass it and I would fail because I'm a woman. I never thought that.
When you, I'm skipping around a little now.
Okay.
but When your youngest child got into 6th grade, what, and before you got the Center for the First Amendment.
Oh, that was long before.
Yeah.
Yes.
Did you then branch out into bar activities or other activities?
I did. When he went to 6th grade, actually I started working more when he was even in elementary school because he had his 2 older sisters coming home from school too at the same time. And I had a mother and father who lived across the street, diagonally across the street, and a sister-in-law and brother who lived down the street. And I had 2 other sister-in-laws within a mile. And my mother and my sister-in-law on my street and I shared the same housekeeper. So there was always somebody around that could help. If I got a call from the school, if for some reason, I usually went home at that time. And in fact, if it was, say, 11 o'clock in the morning and a school nurse called that somebody wasn't feeling well, I'd say, I'll come pick them up. And I'd go to Milton and say, I'm going to go home and pick up so-and-so. And he'd say, you know what, if you wait 5 minutes, I'll go with you, and I'll come back after lunch. So he would do that, and then we would go home and have lunch with the child who usually wasn't too sick. And I would stay home and read to that child. I enjoyed the afternoon. I had one partner who called me and my children a Goldberg, But I didn't mind if they were out of school, and they sometimes stayed out of school. I had one child who went to Yale, but when she was in 2nd and 3rd grade, she stayed out of school at least one day a week, regularly. I mean, she didn't want to go to school. And we made her, and we always let her play hooky on Wednesdays, say. So then on those days, I wouldn't expect her to stay home alone all day. So I would sometimes stay home too. So I had a partner who called me a gold brick, but I didn't mind. I was doing what I wanted, and he could call me anything he wanted. He also called me a paper tiger because I was willing to be very strong on paper, but not quite so controversial in person.
Well, now to get back to my question a little.
Yes.
You branched out around.
Oh, yes. And so at first I just developed more of a practice, and that's probably when my family practice developed most. And then I'm trying to think how old that child was. In 6th grade, you're 13 years old, early 70s, and that was about the time we had the newspaper cases. They went on for quite a while. And then I was much more involved in the practice, and I began to take part in the family law section, and I was chairman of the legislation committee. I had done some lobbying in Hartford and for other clients and so on.
Of the family law or the bar?
No, family law.
Family
Unpaid
law.
position, not paid.
Yeah, right.
And then I was chairman of a committee for the family law section that was reviewing revisions to the estate provisions of the statutes. And there were a variety of different things I did with them. I was quite active. And I spoke at a CLE meeting and so on. And so I did a number of those things. And I neglected to give you a resume, so I didn't say anything about the honors I received. I don't know if you're interested in that or not.
Yes.
You are?
Yes.
And I received a Public Distinguished Service Award from the law school in 1988 or 1989. And then after Milton died, he would have enjoyed it a lot, but after he died, we received a joint Distinguished Service Award from the Connecticut Law Review, and we received a joint award from the Connecticut Bar Association, and a joint award from the Connecticut Daily Newspapers Association, I think, that was funded by that one included an honorarium of $500 that was funded by the New London Day. And so I gave that, Milton was dead already, and I gave that to the Center for First Amendment Rights to launch a high school program, and that's what launched our original high school program. Of course, it costs much more than that, but, and a number of daily newspapers in Connecticut support that program to this day. So I did take much more action in the community. And then later on, I joined the media law section of the Connecticut Bar Association. I'm still active with that. I'm not active in the other sections because I don't actively practice. I occasionally see clients, or I'll help out somebody who's in desperate straits. But I don't really, I like to be sure my malpractice coverage is in place, but I don't really actively practice. And of course, now our law firm has just merged with Pullman Comley, effective just a few days ago, January 1st.
Oh, I didn't know that.
Yes, and so our name is going out of existence. We're taking the Pullman Comley name. Nobody consulted me about that. And I don't object. I think the young people have to do what's good for the young people. And I think it might be very nice. We're moving into new offices. Our offices are 20 years old. They're getting a little run down, and so it's very nice to move into brand new offices at 90 State Street. And Pullman Comley is being very nice. They are giving me an office to use for the Center for First Amendment Rights also.
Terrific.
So I don't know, it will only last until they have enough associates to fill up the office space, I guess. But for the moment, it's very nice. And then the University of Connecticut School of Law has given the Center for First Amendment Rights an outstanding offer to become a permanent arm of the law school.
Wow.
If we raise $1.2 million.
Ah.
And that, they figure, is what would cover. We raise now about $25,000 or $28,000 a year to cover all our programming. We have about 9 programs through the course of the year. And they figure would cover that and cover an executive director. And it really needs more than that because it would need a part-time faculty person, I think, a First Amendment scholar, to provide leadership for the center. And that's a good way to think about it for the future. I might get hit by a truck when I walk out of here. So if I'm not around, unless it has an institutional setting, I think it will be a problem. And so we're in the process of doing that. Paul Newman just gave us $10,000, which was very nice. And we've applied for a grant, a matching grant from the National Endowment for the Humanities. And they didn't give it to us, but they gave us some excellent comments. It's a good government. And they gave us comments about what they felt. And some of them were outstanding. Others were critical, and they were well taken, the criticism. And they all felt, though, the people who valued it and those who didn't, that the application should be by the law school because they are the continuing organization. And I think the law school is going to do that now. And that is $300,000. And we have to match that with $900. And then I think we'll have a Yukon 2000 grant that will help make up the difference. So we have to raise $480,000 by that plan. And I'd like to raise a little more. And so Paul Newman's was a first contribution to that, which was very good. So.
Hey, lots of colleges or universities have centers for this and that.
Yes.
So it would seem to be a...
I think it will be. It gives a good outlet for student activities and opportunities for jobs for students. And volunteering also, and for credit. And we do have one program now, which is joint with the law school and the center. It's called the Alvin Pudlin Memorial First Amendment Fund. I don't know if you knew Alvin Pudlin.
Somewhat.
Yes, and his sons, David Pudlin, who's majority leader at the legislature, and Bennett Pudlin, who holds a position with the state, and Daniel Silver, a lawyer in the firm that Alvin Pudlin started, has raised the money. They raised a basic sum, I don't know, of about $32,000, and it was matched by Yukon 2000 some time ago. And this pays for 2 students from the law school to conduct classes in First Amendment history, principles, values, concepts at the 3 high schools in Hartford. And so that's a very nice program. There are other programs like that that could be done.
Well, Ethel, your daughter went and became a doctor.
Yes.
But certainly, I can't help but take it from talking to you this morning that you think that being a lawyer is good for any person who wants to do it, and including women.
Absolutely.
Yeah.
And I do have a daughter who is a lawyer and a partner in a law firm in Philadelphia.
Oh, that's right. That's
Dilworth
right.
Paxson.
Oh, yes, that's
She
right.
was the first person that taught me that that lawyers move from one firm to another. She was with the premier litigation boutique in Boston after she graduated from Boston College Law School. And we thought she was destined to be a litigator because she litigated with us from the time she was 2. And so she called up one day after she'd been
Was
with
she the one who liked to stay home from school?
Well, she took it from her older sister. It wasn't as essential to her, but she did manage to stay home a lot.
Yeah.
And she even cut school when she was in high school. I would hear that she came home to play with the dog or to watch Leave It for Beaver. She cut classes. But she's a very hard worker now, and even though she didn't work hard then. And so and in fact, my son, who's a federal federal defender, works only 4 days a week now. Since he's had his 3rd child, he made up his mind that he would work only 4 days a week because he wanted to have more time with his children. And he and his wife, who's a clinical psychologist, are outstanding parents. And they are really delightful. And he said to me the other day, I'm going to have to go work 5 days a week and also do more work than you have to do in a government office sometime in the future, I suppose, to send his children to college. But he said, for the moment, while they're young, I'm going to do this. So I think that's
So she
reasonable.
switched from litigation?
So our daughter, the lawyer, when she was our second child, she called up one day from Boston. She's going to leave the law firm she was with, and she's going to get another job. I said, leave the law firm you're with? I was shocked. People stayed in law firms forever. And it certainly was a very good and a very lucrative law firm, and it had prestige, it had everything you would want in a law firm, and brains. And she said, well, this is a family firm. I don't think I have a future here. And I don't like litigation. I said, you don't like litigation? And she said, I went to court today with somebody who was fighting over a copy machine for 5 years. Can you believe anything so stupid? I don't want to fight over a dead case. I'm only interested in live cases. And so she did leave. She called a few days later. She had an offer from a labor law firm. She was thinking of going, then she went to visit her office, didn't have a window. She wouldn't have her own secretary. She didn't like the library, a lot of different things. So then she looked around, she got a number of offers, and she finally took one with a law firm I call the most highly organized law firm in America. I don't know, I knew about them before, but I didn't know they were so organized. But the head of her department went around every morning, Monday morning, with a list of all the cases that everybody was handling, and went to every person and checked up on what they were doing and what the plan was for the week and everything. We never had quite such control in our office. And I thought it was a very organized firm, and she calls up, you know, a year and a half later. She's leaving the law firm. Leaving the law firm. I'm moving to Philadelphia. Moving to Philadelphia. What are you thinking of? You'll have to take the bar exam. Well, I'll take it. If I pass it, I do. If I don't pass it, it's not a calamity. It's not written in stone that you have to be a lawyer. I'll do something else. And she was always a little bit of a rebel. And so I pictured her on a street corner playing her harp. And I thought, my God, what's going to happen to her? But anyway, she passed the bar. And the first week, she got an offer that she went down there. She got an offer from a firm she liked a lot. She'd gone to Wesleyan, and she was interviewed by a man who was about 10 years ahead of her at Wesleyan. And they had a suburban real estate practice, and she liked real estate practice. But it was a $10,000 annual cut and pay. And I said, well, you know, the cost of living may be less in Philadelphia than in Boston. And she said, yeah, but it doesn't seem like I should take a $10,000 cut and pay the first week, first interview, even though she liked the head of the firm a lot. So she went back another weekend, and pretty soon she had an offer for $10,000 more than she was earning at a big law firm. And she went there, a very prestigious law firm, and she was there until she had her first child. Then she wanted to work 4 days a week, and they said, yes, but you know, we don't pay 80% for 4 days a week. Lawyers have to work more than a full week. So she was very offended about that. It was an issue she might have litigated.
What percent would they pay?
I don't think she even asked. She was so mad. And so she decided to leave. And the head of the executive committee was taking a job to run all the city services, legal services, for Mayor Rendell, who had just been elected. And so she decided to leave, and he asked her if she'd be in the real estate department. She had wonderful major transactions she handled for the city, for the waterfront and redevelopment and so on. And she did that for a number of years. And when she heard he was leaving, she decided she would leave. She said, I called up one day and said, I'm going to have to make my resume. This lawyer's leaving, and I think if he's leaving, I should leave. And the next day she got two offers, one from her old law firm, and no, she got an offer for Allegheny Health, a nonprofit, and she went to work for them, and she loved it. She was their only real estate lawyer, and they went bankrupt in a year. They were buying so many things. She had a great time when she was there, but they weren't buying prudently, and so she left. And in fact, she left at a good time. Other people who were there were prosecuted for things. They took money, took bonuses and things. Of course, she never got any. And then she got two offers, one from her old firm and one from a new firm, Dilworth Paxton, and she went there. And she likes it a lot.
Quite a career.
It is.
Well, Well,
that's another career of women.
Things are changing.
Yes.
Well, law firms are merging. And
yes. I think it's still hard today for women to develop a practice that doesn't involve women, like I had the family practice. I think it would be hard to develop a business practice like Milton developed, a corporate practice. And some corporate clients came to me, and they, like we had a corporate client referred by a lawyer in Boston, but it provided a feminine service. And I did a lot of lobbying for them, but I can see why they might have wanted a woman lawyer. But I can't think of many people who came to me first. There were people who were satisfied with the work I did for them, but I don't think I originated many corporate clients. And I think that's probably still difficult for women today. I don't know. People, although we've had women who have originated banking business, that's an institutional kind of business, that's different. I don't know how many, well, I had a construction client, but she was a woman also who headed the construction company. She was a very good client. And so...
And Mrs. Ellis had the newspapers.
And Mrs. Ellis had the newspaper, right. And her husband, though, was a client before she was, had the newspaper. And there have been a variety of male clients, but I'm not positive that I originated any of the corporate clients that weren't headed by women. I'm trying to think of one, and I don't remember one offhand. So that may be a big drawback, because a large part of law relates to business, and even today, men still hand most of the businesses. There are a few women who had any big corporations. And of course, law firms like to represent big corporations. So, however, those that we have had, I still see some executives of corporations that I meet with occasionally, and they're happy to discuss things with me. I don't do any of the, you know, if something has to be drafted, somebody else will do it. So, I don't bill for my time so I can enjoy life, except a couple of trusteeships.
You're like Bernard Baruch on the park bench. Come and get your wisdom.
Yes, right.
You don't have to.
Bernard Baruch once saved my life. He had a school for economists in New York that he set up, and I had a brain operation 22 years ago. And before I had the operation, I was having some kind of a brand new CAT scan. It was a coronal CAT scan, and it was brand new. Nobody in Hartford had it yet. And so I went to a hospital in New York to have it done. And that hospital was under partial reconstruction. And so for whatever reason, I sat in the waiting room all afternoon next to the procedure room where they were going to do this coronal CAT scan. And each time I asked the receptionist, am I next? Or where am I on the list? She would shut me up fast. And eventually she left. And then Milton and Leo went out for supper. And I put my chair in front of the procedure room and I said, I'm next. And so they did me next. And Milton had the wisdom to ask for a copy of the x-ray right then. And the next morning, I called up the doctor to find out, the man who did it, to find out what the result was. And he said it was negative. But Milton we had dropped it off at my doctor's office in Hartford on the way. And he said, I've never seen such a scan before. But in my opinion, it's very positive. And so we showed it to other people. They all agreed it was positive. And I ultimately went to a surgeon at Cornell.
Positive meaning bad. It showed something. Yeah.
Right. And during the procedure, the doctor, who was originally educated abroad, said, I'm not sure I know how to work this. And the young assistant, who said, oh, don't worry about it, I know how. Then the young assistant said, wait, something's not working right here. And he got under the machine, he was monkeying around. I said, what do you do? Are you a resident? He said, no, I'm a student at Bernard Baruch's School of Economics. And he fixed the machine, and he operated it, and he did everything. The doctor did nothing, and he diagnosed it wrong. And so I am always grateful to Mr. Baruch for having his students work in hospitals in New York.
Well, Ethel, I think we've covered the waterfront pretty well.
I think so, too.
It's certainly been interesting to me, and thank you very much.
Well, thank you. I've enjoyed it, too. And you've been a good interviewer.
Thank you. We're through.